Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Nabila Izzati binti Sabri and this is Anis Hanina binti Muhammad Saidin. We are from TLB4. Question number 1A. The question is, what is security transaction? Security transaction or security is a dealings whereby a registered proprietor conveys his land to either a bank, finance company or money lenders to secure the repayment of loan. The land will be a security to assure the lender that the borrower will repay the loan within the stipulated time. If the borrower fails to repay the loan within the stipulated time or breach any terms and conditions, there are two types of security dealings which are recognized under NLC. The first one is charge and the second one is statutory lien. And there are one type of security transaction which is recognized under customary law, and it is recognized by court, which is jual janji. Charge is created when a registered proprietor or a lessee uses his land as a collateral or security in return for the loan given to him by the lender. Statutory lien, as defined by Hawkesbury Laws of England, lien is a right in one man to retain that which is in his possession belonging to another man until a certain demands on the person in possession are satisfied. Jual janji, which is a type of transaction which is recognized by customary law and by the court. It is a type of security transaction and often classified as personal law transaction, practiced commonly amongst Malay Muslim community, principally for purpose of avoiding payment of riba or interest that is strictly prohibited in Sharia. So we go to question number 2, question B. The first issue is whether the security given by Mr. Simba in the form of IDT in return for loan to be granted by Mr. Binod fulfills the requirement to create charge. The requirements to create charge and the conditions prescribed in Chapter 1, Part 16 of National Land Code. Section 242 provides that every charge must be affected by Form 16A or 16B. For Form 16A, it must be for the purpose of repayment of debt, and Form 16B is for the purpose of repayment of annuity or other periodic sum. In order to register the charge, the charger must use the prescribed instrument. In the case of V. Letermanan and Central Malaysian Finance Berhad, it was held that the use of wrong form will not invalidate the charge created, meaning that if the charger use different form, which is the wrong form, it may not be invalidate the charge. And it is confirmed in case of Tan Gigi and another versus Equity Finance Corp Berhad. The court held that the use of wrong form will not invalidate the charge as long as it has no substantial effect and misleading. The instrument must be registered at the relevant land office after the form has been filled. The instrument must be registered in land office. It is provided under section 243. Until a charge is registered, the unregistered chargee has no rights to enforce the charge under the NLC, although recourse under the contract may be available. Therefore, as Mr. Simba did not execute Form 16A or 16B as required under Section 242, the security is unregistered and Mr. Binod may not enforce the charge in the case of default.
Okay, for the second issue is whether the chargee, Mr. Binod, can still enforce the charge under the equitable charge and thus render the charge to be valid. An unregistered charge, or known as an equitable charge, is where the lender takes possession of the issued document of title as a security or an assurance for the repayment of loan by the borrower, but fails to present the instrument for registration of the charge. Okay, the general rule is that an unregistered charge is not valid because according to Section 206, subsection 1, paragraph A and B of the National Land Code, registration is a mandatory procedure. However, according to the case of Mahadevan and Manilal, it has been held that an agreement to secure a debt in favor of the creditor in respect of the debtor's land may trade an equitable charge giving rise to an equitable right in favor of the creditor, although no charge within the provision of the National Land Code has been created. Besides, in the case of Oriental Bank and Chapsa Restaurant, the court held that in the event of the default of payment by the charger, the equitable chargee cannot apply for an order for sale because the equitable chargee does not have the same rights as those of a registered chargee. Therefore, by applying Mr. Bennett's situation to the principles to the case above, okay, Mrs. as Mrs. Simba and Co. did not register the charge, but they only deposit the IDT as the security, it is considered as an equitable charge. Okay, therefore, and thus it is considered valid, although no charge within the provision of the NLC has been created, as been stated in the case of Mahadevan.
To conclude, the rights of Mr. Vinod is only to the extent of equitable chargee and not legal chargee, and therefore the rights of Mr. Vinod is only limited to rights in personam and not right in rem. That's all for us. Thank you.
Thank you.